I'm not a lawyer, but I did stay at a Holiday Inn once. I think it was the 14th floor, Section 3.
You initially said that you thought the Supreme Court would have a difficult time. Your quote that I looked up today was, avoiding the consequence of the plain language of the 14th Amendment. It was obviously a 9-0 call today. So I wonder, what you made of this ruling and if you feel differently now.
I don't feel differently. I think they did have a very difficult time with it because I don't think any of the three opinions make any sense whatsoever. I think these opinions are fundamentally incoherent and they're fundamentally arbitrary. And I think that I think it just shows the difficulty the court had in trying to select an off-ramp here.
That's George Conway, a conservative who was a Trumper in 2016 and was, until recently, married to Tiny Fingers puppet Kellyanne Conway.
Alternative facts.
That's them crying tears of joy after Trump won in 2016. But what happened to George wasn't a religious conversion. I mean, he's still a fiscal conservative. Conway proved to be a man with a spine. And this time, Conway's piñata isn't Trump. It's the Supreme Court and their recent decision to not allow Colorado to enforce Section 3 of the 14th Amendment, which says, you want to be president? You can't do this. You can't have engaged in an insurrection or rebellion against the U.S. Seems pretty straightforward.
But I can't make heads or tails, frankly, out of the concurring opinions any more than I can make heads or tails out of the majority opinion. It's just, it was just all shoddy legal work all around by all the justices.
Okay, at the heart of this argument, though, is whether a state could remove Trump from their ballot because of his participation in January 6th.
We're going to walk down to the Capitol,
which has already resulted in the arrest and imprisonment of hundreds of people. They stormed the Capitol and attempted, among other things, to stop Mike Pence from certifying the election. You know all this. I get it. But there are two underlying principles here. The first is, how much power should a state have to control their elections? And two, does this ruling offer any insight into the court's role in Trump's trial and possible constitutional bonfire this fall?
A lot of us can't figure that out. But we were just talking about the ruling today, and you tweeted today, it doesn't even profess to be interpreting the text.
It doesn't. And I think that's Professor Eiffel said that there was a lot of overreach in the majority opinion. I think the problem here is that all 9 justices underreached. They simply decided that they weren't going to apply the Constitution the way you normally apply it, which is you read the text and you try to figure out what it means in the context of the history, and you apply it. And the plain text of the constitutional provision here says that Donald Trump is disqualified. And so that was the real problem with today's decision. And I don't think I don't make much of the concurring opinions criticism of the majority for having gone too far, because at the end of the day, I can't see where in the majority opinion it does more than say that states can't enforce Section 3 of the 14th Amendment against federal office holders. And, the only difference I can see between that holding and what the 4 concurring justices, the 4 women, interestingly, said was that they probably would have restricted it to the president.
That's really interesting. So Conway, a conservative, is saying that all 9 justices made a ruling that somehow doesn't reflect an interpretation of Section 3. Then what the hell were they doing? Here's a little history. Colorado sued to have Trump removed from the Colorado primary under Section 3 of the 14th Amendment, claiming the amendment's language barred service in federal office for someone who took part in an insurrection against the government and had sworn an oath to protect the Constitution. For the record, early on, Trump's defense was Trumpian, to say the least.
One of the most absurd points argued by the former president was over wording, saying that Section 3 of the 14th Amendment does not apply to presidents because he never swore to support the Constitution, which is what it says in Section 3. Instead, the presidential oath he took says to preserve, protect, and defend the Constitution.
That's where we are, people. Trump didn't deny trying to overthrow the government. He said, I never swore not to. Anyway, all 9 justices agreed in the judgment that such a disqualification power was not held by the states. Beyond that, they showed a difference of opinion over the need to define if only Congress can decide these requirements. Conway thinks they screwed the pooch. He says that basically the court doesn't have a clue.
I want to be a dictator.
Now we have Trump promising that if he's elected, he will arrest political opponents and MSNBC on-air talent. It'd be nice if we had a court that doesn't their pants whenever a case about Trump lands in their lap. They have already shown a bias by delaying Trump's insurrection trial, taking their time to determine if Trump will have immunity from any and all of his actions as president.
If a president doesn't have full immunity, you really don't have a president, because
nobody that is serving in that office will have the courage to make, in many cases, what would be the right decision, or it could be the wrong decision. It could be, in some cases, the wrong decision.
Again, Trump's unique defense. I'm not saying I didn't steal top secret documents or start an insurrection trying to overturn an election and void the democratic desire of 160 million people. No, I'm just immune. And of course, there's concern that Trump's 3 conservative appointments, all members of the Federalist Society, a 42-year-old conservative cabal dedicated to legal reform, look it up, anyway, that they might have an agenda, and that agenda is not in your interest, unless, of course, you belong to an exclusive country club and have a lawn jockey in your front yard. Conway's argument offers some hope that at least 5 justices still have the tenacity to cling to a notion almost universally revered by Americans, that what happened on January 6th is not who we are, and that the court has a duty to protect the Constitution's sole purpose, equality under the law.
But again, there's just no basis, no textual basis, no historical basis
for them
in the
not
14th
to
Amendment
apply.
not to apply it. And the only argument that ever is made in any of the opinions as to why you would restrict states from applying the 14th Amendment, the plain text of the 14th Amendment, the 14th Amendment that contains all sorts of other provisions that apply regardless of whether Congress says, whatever Congress says, including the Equal Protection Clause, which prohibits race discrimination. The fact of the matter is that there's no basis to single out Section 3 as being different from these other provisions. And they're just making it up. And all the justices were making it up.
Why, though? Why? You've studied this court for so long.
Because they were terrified.
Of what? Trump? The reaction?
The reaction.
The Supreme Court is a supreme mess, most notably the seat held by Clarence Thomas, whose wife participated in January 6th and even communicated her feelings that Trump should declare himself the winner to Trump's chief of staff, Mark Meadows. Coney Barrett served as a handmaid in a Christian group called People of Praise and has referred to embryos as people. Alito, like Thomas, has accepted hundreds of thousands of dollars in gifts from billionaire Republicans. And Kavanaugh still hasn't explained who paid off his mortgage. So if states don't have the power under the 14th Amendment to block Trump from the ballot, does that mean they can't switch electors at the last minute if Trump should lose their state? Or can states cross state lines chasing pregnant women? And should Trump be convicted but manage an electoral victory, how far will this court let him go? Conway has proven that Democrats and some Republicans can work together. But with Trump and this court, this time it's for self-preservation.
President for life, that sounds good. Maybe we're going to have to try it.
Shut the up, Donnie. Am I wrong? Damn right. Tick-tock.
You're in a lot of trouble, Donnie.
Follow, like, and hit notifications as Really American keeps you up to date on the latest Republican cult lie in this very important year. For Really American, I'm Chip Franklin.